Yes, ma'am. Your opinion for that? If it is the quarter of 2023, almost 1.5 years. In Goswami learned to put in appearance, affidavit compliance to court, he did respond. Yes, it is there. Notified at that time. Okay. His arrest authority had submitted that an affidavit is filed on behalf of the petitioner in additional affidavit is filed on behalf of the petitioners. In 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 PIL number 29 2020 and affidavit in reply in PIL number 39 of 2020 is filed today only. Stop. It is noticed that today only. And his counsel, Mr. Gogoi, has submitted that he is in receipt of the said affidavits and he wants some time to file counter to the said affidavit. Stop. Is also noticed that on 27/4/2023, the Home and Political Department, Council for the Home and Political Department, and Director General of the Police Assam, who were impleaded as respondent number 13 and 14, were granted time to file affidavits in opposition. However, the same has also not been filed till date. These PL petitions after 2 weeks. In the meantime, the respective councils may file their counter affidavits / affidavits. List after Puja vacation. List after Puja vacation. Puja vacation after any whatever the date.
That 143, 140.
Last petition, it is covered by the 154. Why? Once the assessment proceedings are not over and in between you have reopened it. But that what they are claiming that as per the Honorable Supreme Court, once the assessment proceedings are not finalized, no order for reopening the case can be given. So the principle is the same. But they are relying on a Supreme Court judgment. On that day, last opinion, who's appearing on behalf of the respondent? But he on that day submitted that he is in not contact with the clients. Now he is able to contact the client. Password for the day. Password for the day.
From item number 9 to 17. Daily list for hearing item 1.
What's the ability? In the election petition. Writ of co-warrantor. Writ of co-warrantor was allowed or what? Election pertains to which concept? Let me do it. Okay, Monday.
For hearing item 1.
Government is not interested in protecting the selection process, then cancel it. Why you are why you are asking the court to do when you yourself are admitting? Seize of the matter, we can very well pass this order that if the government takes any decision regarding this election process, there is no bar from this court. This is your. It may be clear the government is not interested in protecting selection without any prejudice to the final outcome of the criminal case. That's why you are depending upon the court. You yourself are admitting that there are serious irregularities. Cancel it. It is within your authority. Till date, no appointment was provided. But if there are discrepancies in the selection process, They can that resulted into interview denial means cancel that result and again.
Yes, the case the prior original without relation.
That's only we have simply if there are discrepancies, there were discrepancies in the selection process. Hold a new one by conducting interviews if law permits so. Only by the viva was a test. Law permits to do so. That was his challenge. That was the petitioner's challenge before the learned single judge. And learned single judge said that that rule permits this selection on the basis of viva also. That's right. If that is the position, then certainly the state government can again.
Facts are of such nature. Otherwise, people also find that without taking to relation, based on that, because we are it is evident itself in it so that original interest of we maintain. In which there are
But now we cannot find out. Is it? If it's on, what? What is it? Because one thing. One thing is that it is I must.
now
And Mr. Chaudhary, the thing is that if we direct them to restore the original position, the marks that also, in fact, once it is compromised,
we see it I can have that. Now I can show lot of which is the order. The list of candidates for pilot get interviewed with district manager officer under it was submitted by
yeah, it is there. Just,
and it's initial part,
just
final marks after the candidates got 9 of here. He secured 82 marks.
marks obtained, including the petitioner. No, in fact, they have provided a select list for the recommendation as per the original without alteration, reduction, enhancement. Yes.
I was submitting based on that my interpretation today. Without alteration. Nobody changed the debit of the law. Okay. That my lord, this candidate for data secured 82, but it was reduced to 80. Then attitude is not secured 74, it was made 77. So it go. Serial number.
Usually Rahman, no, this Rahman is that serial number?
Without serial number other than Islam.
No.
It was increased from 74 to 77. Since secured 73, it was reduced to 69. However, it both yeah, outer than the order. So whatever say your
It is one Deep Jyoti Sharma.
yes, the
She was
68
and 75.
So specific
It's very, once it's almost in all the results except 4, 5.
there are also decrease. For example, without call. I because the Baham 71 made 70. Kumar 71 made 70. Hindu Muslim Doctor 75 made 70. Then Sena Begum 70.
The thing is that almost 50% of the candidates' results were interfered.
That equal party was okay. It's not that other person. For my part, that is what the party of the drugs. I can only take it up. It will be very lot in Motila Padapa's case. Would say
Yeah. Maybe in this case or another case. What is your this on this point that this only on the selection only on the basis of I will say it can be done?
can be done.
That you just argue on that point whether it can be done or not, because now we have to decide the appeal. You just I start arguing. No, that aspect, since you have challenged it, and learned single judge has given a finding. If you are challenging that finding, that selections on the basis of viva say is not permitted. That's another thing, sir. For the time being, what do you mean by for the time being? We have to decide it finally. Either we have to affirm this finding of the learned single judge that yes, a selection can be done on the basis of Viva Voce. And if it can't be done, then another ground is available. Pass over for the day. Next, on the next any occasion, on the evening day, you just satisfy us. So far as regarding, apart from that, this, what are the irregularities are there and so, that is writ large, and what mechanism we have to adopt, either to consider the original marks or to have fresh de novo interviews, whatever it may be, but first of all, Tuesday. Tuesday. At least, sir, it's a hearing matter. It should be. Yeah, Thursday. It's not fair on your part, Mr. Phuket Jantar. Once the state government is of the opinion that it is not fair, then it is. Argue no. Once the state government is the opinion that yes, there are irregularity, and then why to depend upon the court for that reason? You can do very well. It seems then you are protecting those people. Yeah, that's the only thing. Why you? The entire matter, the court has not been. This is something very bizarre. Then we have to comment. Then we have to make certain comments on this stand of the state government. We are saying yes, there is irregularity, but we are not going to cancel it. Cancel, you cancel it. So what was the intention of that order? What was that intention of that order? We are not protecting, sir, but we are not going to cancel. This stand is absolutely. Then we'll make some comment on that. Then you'll move an application for expunging that and everything again. Our message was loud and clear. There was no confusion about that. But if you are not acting on your own, then okay, be ready for some observations or whatever. You take it. If you want by Thursday, you take it. Take the decision. And it's better, without cancelling all this, hold a de novo interview. They are agreeing for that. That would be the proper thing. That okay, again, have an interview, and whoever gets the mark will be appointed. Consider. Take a decision and in black and writing and place it before us. Then only we will do. Whoever on Thursday, complete your instructions. Sure.
These rules have been consequently amended. Can you get the amended rule? Now I think it's combined. Written exam. No. Now the rules have been amended.
average. And we follow another practice. Will average.
Yeah, but
Weak supply.
Item 8.
Okay. Yes. Respondent number one, who is respondent number one, which department? No, sorry, this appellant number one. Which department is responsible or is it's called. In last occasion also we granted him time to provide him alternate line. We can't, pass over for the timing call. Call Mr. Bhojpuri.
Item 9 to 13.
Who is on like?
Advocate General, madam. He is on legs, madam. One Pathak matter is going on. Madam.
it's like,
Item 9 to 13. Madam.
This item 9 to 13 will hear to copy and then we'll take
My lord, what had happened on last occasion, actually the facts are like this. My lord. We were actually grade 4. And subsequently our services were regularized. Now the issue is whether a regularized employee, whether they can earn a promotion. Now, my lord, a division bench of this honorable court has taken a view that since the appointment is to a particular post, personal post, therefore there cannot be any question of promotion. And on that, there are Supreme Court judgment which says there can be promotion. That is one point. But my lord, on last occasion, when the last time matter was listed, then my lord, the then Honorable Chief Justice made a suggested to the government whether the assured career progression scheme can be extended to this appellant. So, my lord, that is how, my lord, the government was also asked to obtain the instruction. We were also asked to consult our client. Now, my lord, we have consulted our clients are agreeable.
But any, I think that this
But my lord, but it is
Moral
not
of-
reflected in the order. But my lord, this view was, given by the honorable court. During the course of argument, my lord, this thing has transpired. In fact, there is one judgment of the Supreme Court. Can I place it? ACP rules I haven't brought, my lord. Okay. My lord, what I find, my lord, subject to what your lordship may say.
Yeah.
There is nothing like personal post. My lord. The concept of personal pay is there.
Ex-cadre posts.
My lord, as far as posts are concerned, there are, my lord, personal pay, then temporary posts, tenure posts, permanent posts. There's nothing like personal post.
So they have used it as a personal post nomenclature, personal post. These are the ex-cadre posts.
Could be. Could be. Well, in a given case, yes. Now, if your lordship would kindly come to page 17 of the memo appeal ground B.
Yeah.
That is what I would like to contend, my lord, in item number 10, my lord. For that the term personal post is a misnomer. In as much
Para
as,
22 of the appeal.
my lord, item number 10. My lord will kindly come to page 17, ground number B.
Ground number.
Yes. Or that the term personal post is a misnomer. In as much as FR 923 speaks of personal pay.
Just, yeah, okay.
I'm sorry.
Yes,
Yes.
for the
For that the term personal post is a misnomer, in as much as FR 923 speaks of personal pay. As provided in FR 923, personal pay is granted to a government servant to save him from loss of substantive pay in respect of a permanent post other than a tenure post due to a revision of pay or to the reduction or to any reduction of such substantive pay otherwise than as a disciplinary measure or in exceptional circumstances or for other personal consideration. Having regard to the meaning of the personal pay defined in FR 923 and also having regard to right to be considered for promotion, which has now been elevated to that of a fundamental right. The stipulation in the impugned order dated 25/11/1913 that regularized workers and master workers cannot be considered for promotion as per rules of 67 is wholly arbitrary, discriminatory, and capricious, and hence the same cannot withstand the judicial scrutiny. In any case, right of the appellants to be considered for promotion cannot be taken away by any executive fear. Well, at the end of the day,
yes,
my lord, as per the Honorable Justice Nair was referring to that government OM, my lord.
Yeah.
That is 6th of July 2017.
Yes.
Yes. Now it says MACPC would include grant of financial upgradation 3 times in the entire service period, that is on completion of 10 years, 20 years, and 30 years, to those employees who do not get one regular promotion within the first 10 years, or 2 regular promotion ACP benefit within 20 years, or 3 promotion within 30 years. And my lord, it includes everybody or excluding. This scheme should be known as Modified Assured Career Progression Scheme for the regular state government employees. So I'm a regular state government employee. Even if I'm in ex-cadre, In fact, my lord, in the earlier division bench judgment, this aspect of personal pay was not considered. More or less in a similar circumstance, there is a Supreme Court judgment, 1992, 1 SCC 331. P31.
Yes,
My lord, what is fallen from Honorable Justice Nair regarding that scheme, my lord? Otherwise, because we are not no longer work charge or master roll.
no, you are regular employee since the day they have regularized.
So therefore, in any case, we'll be entitled to that MACP. That is one aspect.
That-
Now, my lord, regarding whether the employees of the nature to the class to whom we belong, whether we have a right of promotion or not, are considered by the Supreme Court in one case. My lord will kindly come to page 332, para 2. Briefly, page 330.
Yes.
Briefly, the appellants were originally appointed after interview by selection committee, but only as ad hoc appointee in the above survey. They were appointed on various dates between 68 and 77. Their grievance is that despite their long service in the department, they were not regularized with reference to their original date of appointment. Union of India pointed out certain difficulties in giving effect to the order of this court of April 1987 by filing a review petition and then clarification application, but these have been dismissed. The resultant position is that all appellants have to be regularized in Group A of the Central Health Services with effect from January 1, 1973, or the date of their respective original appointment, whichever is later. We may mention here that January 1, 1973 is mentioned here because the appellants have now expressed their willingness to be considered for regular appointment only from this date and not from any earlier date. This being the date on which Group B and Group A services were merged together by Government of India on the recommendation of the Third Pay Commission. Only difficulty experienced by Union of India in giving effect to the direction of this court, which now subsists, is that if regularization is granted to all the appellant doctors who have been regularly appointed in Group A after an interview by Union Public Service Commission, may get relegated to secondary position in view of the fact that the appellants were appointed much earlier, though on an ad hoc basis. These regularly recruited doctors have not been heard earlier, and they have now come up with intervention application, praying that order of regularization of the appellant should ensure that their interests are not prejudiced. This was also the anxiety of the Union of India as expressed in the counter affidavit filed. After hearing all counsels, we are inclined to think that while the appellants should get their rights, which were declared by this court in its earlier order, there should at the same time be no prejudice to the doctors appointed to regular recruitment by Union Public Service Commission. After some discussion, counsel for the appellant agreed to put forward certain proposal which should safeguard their interests and also at the same time not prejudice the regular appointees to the Public Service Commission. The essence of the proposal made by them is that they may be treated to be a separate category with their own seniority list and entitled to promotion in accordance with the seniority list. The problem of conflict with the direct recruit being avoided by creation of appropriate number of supernumerary posts. Union of India is not agreeable to accept this proposal, which was set down by the appellant at our instance in the form of an affidavit. The proposal of the appellants have been set down in an annexure to an affidavit filed by Sri so-and-so, dated so-and-so. However, after considering the matter, we are of the opinion there is no way of rendering justice to all the parties before us, except by accepting this proposal in the manner to be set down particularly, because we find that while making the proposal, the appellants have also to some extent expressed the willingness to forego certain rights, and that might have accrued to them in consequence of the earlier order passed by the court. We are of the opinion that the proposal made a reasonable in the circumstances of the case, and that they would not also in any way prejudice the rights of the regularly recruited doctors. In view of this, we direct the following proposal be implemented by department by way of giving effect to the order of this court in so and subsequent clarificatory orders passed by this court. Each of the appellants will be treated as regularized in Group A of the Central Health Services or from the date of his initial appointment in this service, whichever is later, in order to ensure that there is no disturbance of seniority and promotional prospect of regularly recruited doctor. There will be a separate seniority list in respect of the appellant, and their promotions shall be regulated by such seniority list, and such promotion shall only be in supernumerary posts to be created as mentioned below. Each of the appellants will be eligible for promotion to the post of senior medical officer or chief medical officer or further promotional post therefrom, taking into account his seniority in the separate seniority list, which is to be drawn as per indicated above. The promotion of any of the appellant to the post of senior medical officer, chief medical officer, and further promotion post therefrom will be on par with the promotion of regularly recruited doctor who is immediately junior to the concerned appellant on the basis of the respective date of appointment. In other words, if regularly recruited doctor on the basis of seniority list maintained by the department gets a promotion as senior medical officer or chief medical officer or further promotion thereafter, then appellant who was appointed immediately earlier to him will also be promoted as senior medical officer or chief medical officer or further promotion therefrom with effect from same. Now, this is important. In order that there may be no conflict or any possibilities of reversion, the post to which the appellant will be promoted, whether as senior medical officer or chief medical officer, should only be to a supernumerary post. Such supernumerary posts should be created by the government as may be necessary to give effect to the above. So, my lord, when we are regularized, my lord, we are regularized by creating a supernumerary post. Okay. 1990 supplementary 3 STC 217.
He passed this, any order in the line of theirs.
Yes.
How many supernumerary posts they are required to?
Not many,
create?
my lord. Not many. How many?
Why?
My lord, the moment we retire, my lord, this post will go.
How many?
Not much, my lord.
Proportional posts.
We don't agree. I think there will be about 15 odd posts, my lord.
3,000 superannuation.
No, no, Milord.
Yes.
Oh, for regularization, they were created. Yes.
Yeah, that's Dr. Smith, I think it was around
15,
40,
16.
15, 16, Dr.
In this
Smith.
case.
So that-
And my lord, in Indrasoni's case, my lord, one of the questions which propped up was whether for the purpose of Article 16(4), whether an ex-cadre post could be included. Supreme Court says yes. Even ex-cadre post is also a post. So therefore, my lord, that judgment of our High Court, my lord, I think it was delivered, my lord, without considering all these relevant aspects.
which you have suggested, Mr. Chaudhary, that this benefit of the MSCP scheme
Yes,
is that maybe one of the factors that the state government respond to that.
yes, my lord. In fact, this was the question which this honorable court posed to them. In fact, my lord, the matter has been listed after a long time today. Maybe that is why they may have also lost track. Otherwise, had it been listed immediately, they would have remembered.
When Mr. Advocate General is coming,
Madam, one
still
part,
arguing.
one part matter is going on, madam, in court number 20.
In fact, I appeared for the petitioner in that case. I have concluded my part. He is giving the reply. So it is likely to take some time. We can have this maybe, my lord.
No, will clarify. Yeah.
Order.
The petitioners were, the appellants were initially appointed appointed as must roll employees. And what are other posts? Must roll work charge
Yes.
as work charge / must roll workers in different government departments.
My lord, we are watchers, not master rule.
Work charge from must roll workers in water resources department. Later on, the state government has regularized their services from which date?
Sir. 22nd August 2005.
22nd of August
Yes.
2005.
2005. While mentioning that the posts on which their services are regularized would be personal posts. Full stop. When the state government has not granted benefit of promotion to the appellants, they approach this court by way of filing writ petitions. However, the learned single judge has rejected the claim of the appellants. The interim judgment is dated
18/5/2021.
18/5, judgment and order dated 18/5/2021 while relying on the decision of the division bench of this court rendered in Shri Dilip Talukdar and 21 others versus State of Assam and 5 others reported in 2017 to GLT 135. Would stop. Learned counsel for the appellants have argued that the learned single judge has not taken into consideration the overall position of law involved, overall position of law, and has passed the order simply on the basis of the division bench judgment passed by this court, which is which is clearly distinguishable. Full stop. The net concept of the appellant, Mr. Chaudhary, has also submitted that even though without admitting that the appellants are not entitled for the benefit of promotion, since they have been since they have been declared as regular state government employees, they are entitled for the benefits under the modified assured progression scheme MSCPS applicable to the regular state government employees. Full stop.
Don't they kindly mention the date with us? That the government, it will be easier for them to take it.
Scheme the dated 6th of July 2017. Without deliberating further, we are of the opinion that the state government should clarify this time whether the appellants who are now regular state government employees can be granted benefits of the modified assured career provision scheme introduced by notification dated 6th of July 2017 or not. So this issuance of for the Advocate General is granted time to complete the instructions on behalf of the state government by the next date of year. Then
After 2 weeks,
this on 23rd of October.
Right.
23rd of
public.
April.
which one? Item number which-
Item number 8.
I apologize, but there was cut off in because of some poetic area. Now, Joseph has made a pointed query the last occasion also. Matter pertains to my lord that the petitioner was
Either give him alternate land or compensate him.
compensated. We have given him alternative land, which is according to the petitioner is not habitable.
Yes.
Yes. Now, I have had a discussion with the revenue authorities. They say, my lord, that it is absolutely habitable.
Whatever it may be, if he is not agreeing, compensate him.
Then-
Grant him monetary benefit.
Now, only my lord, the lead court has directed the Commissioner and Secretary Revenue Department as well as the Deputy Commissioner, Amrut Metro. My lord, to either, my lord, give him alternative land or to compensate.
Yes.
Now, the appeal is by these two authorities before this honorable court. So I pray, my lord, the direction, if it is, my lord, at the end of the day, if it is the direction that is going to flow from this honorable court, that is compensate, the direction should be to all the authorities. Particularly, my lord, the sports department.
Okay, the authorities, yes, we are directing now. You please complete your instructions to compensate him. How much compensation you are offering?
So that, my lord, will have to, my lord, formulate, my lord. So therefore, we'll have to, my lord, calculate and find it out, my lord. To that extent, my lord, in fact, my lord, there was a move, my lord, from the office of the Deputy Commissioner to the, my lord, sports department. That, my lord, that the.
Ultimately, it is the state government, sir. We are not concerned with which department is doing,
No,
doing
my
what.
lord, because the money will have to be procured, my lord. Money will-
Procure, then it is the state government which has to procure money. Departments, irrespective of any department, you are supposed to provide money.
That is the difficulty, my lord. My respectful submission will be that, my lord, Lordship will be pleased to, my lord, issue direction, my lord, in case of compensation, my lord, payment of.
You are appearing on behalf of whom?
But for the appellant,
For the appellants.
for the appellant.
And now what you are seeking that directions be issued to whom?
Definitely to the appellant as well as, my lord, to the respondent number, my lord. 2, 3, my lord, 4. And 5 also, my lord,
Why?
because it is, they are the authorities, my lord, who have at all, my lord, caused damage to the petitioner's land, not the, my lord, the revenue authorities.
It is the responsibility of the state. Why you have allowed the central government agency to do the this work, whatever it.
My lord, the national.
We are not, no, we are not going to expand this scope of this. Either you comply with it or otherwise you face the consequence.
The lordship will kindly accommodate me for some time, my lord. I will take up the matter with the authorities, my lord, so far as the compensation is calculated.
The learned single judge, while disposing of the writ petition number 4309 of 2017 by the order dated 20th of January 2021, directed the respondent number 127. Who are the respondent number 127?
So 1 and 7, my lord. My lord, the commissioner and secretary, my lord. Revenue department as well as the deputy commissioner.
The respondent number 127 of the writ petition to access and pay the damages caused to the petitioner, caused to the private respondent herein, and to compensate him at the earliest. The learned single judge has also suggested that alternatively, the private respondent may be compensated by providing separate plot of land as per the settlement rules. Full stop. The said directions of the learned single judge are required to be complied with within a period of 60 days from the receipt of the certified copy of the order. Full stop. It appears that this appeal is pending since 2021, and every time 2021, and in between, the government of Assam Revenue and Disaster Department Management, in bracket settlement department, has offered alternate land to the private respondent. However, the said land was not acceptable to him, and this court has granted time to the appellants to suggest any other appropriate land. Full stop. It appears that despite all the efforts made by this court, the appellants have failed to provide a alternate land to the respondent, private respondent of his choice. Full stop. Taking into consideration the above fact, we direct the respondent, appellants, to access and pay damages to the private respondent for the damages caused to his property within a period of 2 weeks from today. Accesses and pay. That's all.
It will be too late. For
Why?
the time.
Why?
My lord, the authorities
How much land is there?
my lord, it is,
For that, the state government is not having fund. Who katas of the land? How much compensation you are?
because of the
It's not thousands of square hectares, or we have not asked for hectares of land.
No, my lord, that is true.
That is not possible, sir. 4 weeks. What do you mean by 4 weeks? For the state government, it's a mere amount, nothing.
they will have
within a
to,
period of 2 weeks.
the authorities will have to undertake a minor verification exercise. That will require some time. Verification exercise will require some time.
We direct the appellant number 2 to access the damages caused to the property of the private respondent and to submit the same before this court by way of filing an additional affidavit within a period of 2 weeks. List out on so and so. You access the damages and show it to us, then we'll pass an order that this authority will pay the amount within a period of week or 2 weeks.
And so,
You have to, this 2013 Act, in accordance with the provisions of 2013, you have to access the damages. Land Acquisition Act, in pursuant to that, you have to access the damages.
that land has not been acquired, my lord.
Well, it's almost acquired, you have used it, damaged it, it's as good as acquisition. Though strictly speaking, it is not acquired, but you have to pay the compensation as per the provisions of that. Applying that formula.
Can you indicate?
Not that, there is no question of indication, you inform the DC.
Obliged.
Time of that.
Third of October. For hearing, item 14.
I'm sorry, my lord, I will wait.
Yeah.
I was in a border meter before. I was
All first time.
This is regarding settlement yesterday. And my lord, the settlement given to the private respondent was challenged on the ground that the Bakida clearance certificate was in the name of an office bearer of the society and not in the name of the society. And my lord, it was mandatory under the, my lord, the tender clauses, as well as, my lord, they got another gazette notification of the government that it has to be in the name of the society and invariably in the name of the society, not in the name of the, my lord, office bearer. What the, my lord, authorities in the government, my lord, additional secretary did is that he has noticed that the certificate is in the name of the secretary of the society, but he has taken it to be a,
Pakija certificate to the, of the society.
yes, my lord. So, my lord, that was challenged and this was, my lord, urged before the honorable single judge. Honorable single judge has, my lord, accepted this contention. But then, my lord, there was a subsequent certificate which was issued in favor of the, my lord, private respondent in the name of the, my lord, society. And, my lord, that was directed to be considered for the settlement. And pursuant to that, my lord, the
Subsequent
settlement has been-
certificate, what do you mean by subsequent? After the last date of submission of that.
Yes, my lord, much after. Much after, my lord, if your worship kindly come to the impugned judgment. It starts at, my lord. These. It starts at page 384.
এই এইটো এই নাম্বাৰটো কি হ'ব তাৰে এতিয়া আমাৰ এপ্লিকেশ্যনখন এপ্লিকেশ্যন কেইখন আছে এতিয়া 75849 এই আগৰ যেতিয়া বিলটো মই যে approve কৰিছো, কি গ্ৰাউণ্ডত আছিলে এই 1441 issue কি আছিলে কি গ্ৰাউণ্ডত আছিলে বেলেগ বেলেগ গ্ৰাউণ্ডত ডেইলি এখন ৰিপিটিশ্যন ফাইল লাই কৰে নেকি আজি এটা গ্ৰাউণ্ডত কালি এটা গ্ৰাউণ্ডত কোন দেশত আহে তুমি সেই পিটিশ্যনত গ্ৰাউণ্ড সদায় সদায় গ্ৰাউণ্ড মাছমৰীয়াৰ লগত আমিও তাৰ মাছমৰীয়া হ'ব নোৱাৰো আমিও মাছমৰীয়া
My lord, the honorable single judge has accepted my contention. Thereafter, my lord, cited by paragraph 7 of the judgment.
There are 7 of the judgment.
Your lordship, may I, your lordship, permit me to read, my lord. In this paragraph 7, I am reading. In this circumstance, although the decision of the joint secretary in the impugn order dated 17/10/2022 is contrary to the provisions of clause 4 of the notification dated so and so.
In the circle, yes. Yeah,
But in view of the fact that subsequently a corrected certificate has been issued, that is on my lord 10/11/2022 at page my lord 382. And also earlier certificate which was incorrectly issued was not because of any fault on the part of the respondent number 8 society. My lord, this is a my lord wrong finding. This is a wrong finding, my lord, that there was no my lord fault on the part of the respondent society. Then my lord, I'll take your lordship to that document, my lord, to show that my lord, that was the fault of the my lord society. And further that at the relevant point of time when the Pakistan clearance certificate was applied for, there was no Pakistan proceeding pending against the respondent number 8 society. We are of the view that the connected certificate issued to the respondent number 8 society may be taken as the appropriate material in the tender process by the settling authority. We observe as such, in view of the fact that the circumstances in which the incorrect certificate that 12/3/2020 was issued to the respondent number 8 society, and also the fact that at the relevant point of time when the application for obtaining the certificate was made, there was no particular proceeding pending against the respondent number 8 society. It would be permissible under the law to take into consideration the corrected certificate for the purpose of the tender process, in as much as the earlier incorrect certificate would be in the nature of a curable defect. Now, my lord, may I take your lordship to page 381, my lord, this is report,
300 and
my lord, 381. Report of the Deputy Commissioner, my lord, after the,
yes.
may I read it, my lord? Messrs. Garamari Town Panchayat, the private respondent hearing. Mean Samvaj Committee Limited has placed an order dated 4/11/2022 passed by the Honorable Guwahati High Court in WPC number such and such, whereby the Deputy Commissioner Deputy was directed to issue a fresh certificate clearance certificate in continuation to the certificate issued on 12/3/2020 in the name of the same society on due consideration of their application dated 2/3/2020. In the said order, the Honorable High Court has referred the content of the application dated 2/3/2020 by which Sri Anil Chandra Burman, Secretary of the aforesaid society, had applied for issuance of Bhaktidas clearance certificate in the name of the society. As per the contention of the petitioner society, the Honorable High Court in its order dated 4/11/22 has observed that although the Secretary of the society had applied for issuance of Bhaktidas clearance certificate in the name of the society, but instead the Deputy Commissioner had issued the certificate in the personal name of the petitioner. Then your lordship will read further, my lord. After making necessary inquiry, the undersigned has come to learn that the society had applied for Bhaktiside clearance certificate through e-governance on online process by an application format dated 3/12/2019 in a common service center of Dhubri, Bagulamari, by CS number so and so in the name of Anil Chandra Burman, Secretary. The Secretary, Mrs. Garamari Gaon Panchayat, Mean Assets Limited, and not in the name of the society. So, my lord, that was a wrong submission made before the Honorable Single Judge, and accordingly, the Bhaktiside clearance certificate dated 12/3/2022 was issued in the name of the Secretary Anil Chandra Burman digitally. Since the aforesaid certificate was not issued on the basis of the application dated 2/3/2020 by the undersigned, and there is no such provision of issuance of Bhaktiside clearance certificate manually, it is hereby directed to the e-governance authority to issue a Bhaktiside clearance certificate afresh forthwith in the name of the society, Mrs. Garamari Gaon Panchayat, Means Commercial Limited, represented by Secretary Anil Chandra Burman, in compliance of the order passed by this honorable court.
What is the order of the court? In
Order of the
compliance
court.
of which this certificate has been issued?
That order, my lord. Seven,
377.
my lord, 377.
This is by the respondent society writ petition.
Yes.
And you are party there.
Yeah, is the part.
So why you are not challenging this order of the Learned Single Judge?
No, my lord, may,
Learned Single Judge has wrongly observed that there is no fault on the part of this respondent society. Why you are not challenging that order?
my lord, when the matter was moved on the same day it was allowed, my lord, we did not take any opportunity.
But that is, then you should have filed an appeal. This order, the court has granted that the certificate was issued under the direction of the court. And what's wrong with the decision of the authority to consider the same?
No, my lord, it has been, my lord, we have not challenged this order, that is one aspect, but.
That is the only aspect, sir.
My
That is
lord,
one aspect, how it can be one aspect.
no, my lord, also to that, my lord, the Deputy Commissioner has passed an order. And thereafter, my
And
lord,
issued a certificate pursuant to in compliance of the court's order.
Yes, my lord.
And they've
Even
considered
then,
that
even
certificate.
then, assuming my,
What's wrong with that?
even then, my lord, this certificate is a fresh certificate. And this fresh certificate cannot be considered on the date of the, my lord, the last date of filing of the petition.
That is,
Okay.
when this last date was there, last date,
My lord, the tender was retained, my lord. NIT was 20, 27 to 2020.
27 to 2020.
NIT.
And last date,
But there are 50 things. There are also been kind of 200.
so now these very much controversy, they contended before the learned single judge that we have applied for that for the tender and we have applied for no dues or whatever the certificate. And the authorities have granted it incorrectly in the name of secretary of the society where the certificate should be in the name of the society.
Yes, that is what.
The court has directed them to issue a certificate in continuation of that order. That what remains, sir. Ultimately, it is the court's order. How can we ignore this order, sir?
Your worship will, there are other grounds on which the my lord challenge was
Which
made.
other
I am not
ground?
on those grounds, my lord. I am not, what I am, my lord.
The
trying
learned
to-
single judge, before the learned single judge, we have raised this, that this Bakaiji certificate was not in the name of the society and therefore they have wrongly considered their bid.
Yeah.
That is there, now the court has clarified it.
No, my lord, that was one of the grounds. But what happened, my lord, after this order was passed by the honorable single, my lord, the settlement has again been given to the private respondent. And my lord, that is under challenge in, my lord, another writ petition.
That is pending.
That is pending.
So now what
No, my lord.
remains in this
No, my lord,
petition, sir?
unless, my lord, your lordship interferes in this, my lord, I cannot urge before the, my lord, honorable single judge.
What is there to interpret in this?
That, my lord, his finding is wrong, my lord. that is-
No, well, once you have challenged this settlement, that is in separate proceedings, you pursue that proceedings.
No,
Now
if your
this
lordship,
matter
my
is
lord,
to an end.
clarifies that I can take all the grounds, include the ground taken in the settlement, my lord, that will be.
Sir, how can we allow this, sir? In that appeal, only those grounds you have, and that writ petition has been dismissed.
No, that is pending.
That writ petition is pending.
Fine.
You raise if it is, if you have been permitted to, you raise whatever the legal ground. But here, I don't think so. It's only a.
This finding is wrong, my lord. That, my lord, there was no fault on the part of the, my lord.
Sir, you should have challenged it. You were party there. It's a attained finality now.
Your lordship, my lord, goes through that order. My lord, your lordship, my lord, will kindly bear with me. Your lordship will kindly go through the earlier order. 377.
Yeah.
Because at that point of time, we did not know, my lord. We knew only when the, my lord, deputy commissioner passed the order.
Sir, you knew Deputy Commissioner has passed order when?
Deputy commissioner's order, my lord, is 9/11/2022.
And this order is dated?
This 10/11/2022.
Enough time was there before you. You challenge this order. 4/11/2022, enough time was there.
So 4/11/2022 was the order of the honorable single judge in the earlier.
In pursuant to that,
Fine.
the certificate was issued by the authority
Yes.
in favor of the
Yes.
respondent society.
Fine.
Then you came to know that it was fault of the society. Should have immediately challenged this order. Limitation was there. Now it is.
No, what happened, my lord, in our case, there was an appeal filed. There were so many, my lord, litigation here. And there was because, my lord, there was another writ petition 1441. And my lord, the honorable division bench remanded the matter, and which matter was remanded, my lord, that was not very clear. Then, my lord, for a clarification.
That's altogether different thing. This is what the
This is
dictate of. Those were orders.
Deep blue.
Item 15 and 16.
There are two appeals. If there are two appeals in item number 15, the value of the appeal is 1 crore 72 lakh. Secondly, by notification, the comment has enhanced the.
2 crore.
2 crore.
जाएगा
This appeal of it, given option will be to be sure. But if only that question of law may be kept. That
this item number 15.
15.
वही कौन- The order here pass. Will pass. Yes, 16.
If subsequent question of law was framed on the 3rd of March 2023. Two questions. Whether the order secretary part in determining the applicability of application certificate of 1999. The second question was whether the DIC certificate issued if it 10/5/1993 took form for definition of stored deposit during the expansion period. It was civil credit. The notification number 33 of 99. The cutoff date was to be fixed on or 24/12/1996.
Yes.
But if in this case, the proposed notice was issued, but the order in original was dropped. Thereafter, the department proceeded the matter was placed before the committee. Committee come to conclusion that there are substantial question of law involved, so we will approach that CSET. We approach the CSET dismiss our. Now we have a pictorial of it. Approximately for appreciate the fact, approximately come to page 69.
Yes.
I have to place for the facts of it.
Yes.
Mr. Hindustan Coca-Cola Beverages Limited, Surat. If I want to show Lordship that they have closed their limited Surat. Long ago.
Whatever it may be. Another some.
Even if the referred to is said it has alleged to have wrongly availed the exemption notification number 33 of 99, page 8799 as amended and submitted executed document to the department to suppress the actual installed capacity and substantial expansion and installed production capacity and consequently avail the exemption notification number 24. As a result, they got erroneous refund of 15 crore 4,35,055 for the period from July 99 to November 2002. Accordingly, proposed notice number 22 was put for recovery section 11A of the Central Excise Code. After the notification number 3399 as amended and exhibit and fiscal unit being into existence on or after before 12/1997 or fiscal unit on or prior to 24/12/1997 have undergone substantial expansion. At least 25% of full capacity of production shall become eligible to pay in demand if the trade through count and contract. Accordingly, the trade is submitted following document in support of their claim of substantial expansion to the extent commissioner Central Excise. Number one, certificate issued by the general manager, fiscal factor, Surat, dated 10/5/1993, indicating that the actual capacity of production 9 lakh carat as on 10/5/1993. The certificate issued by the general manager DIC, Central Jorah, dated so and so, indicating that the annual capacity of production single ship as 14 lakh 1,000 carat of it. The certificate issued by the authority authorized signatory of the SEC dated 2/7/1999, indicating annual capacity 340 total units. This show total machinery, the lot of capacity expansion have been funded. Based on the above document, the Action Commissioner Central Excise draft by Dr. Dated 2/12/1999 granted provisional refund of the SEC of the said SEC. The notification at 93 of 99 as amended. Thereafter, in or investigation conducted by the anti-evasion unit, Central Excise below found that the said SEC had wrongly addressed the exemption notification number 24 as amended by way of one suppression of fact to no expansion legal machinery related to the input capacity. The wrong assessment of the input capacity. Detail of the inquiry report are as suppression of fact. One, the valuation report of Jorah Food Board as on April 1998 at the time of taking our unit by Messrs. United Soft Drink at the said SSC. If compared to the report submitted by the said SSC, revealed that several machinery equipment had existed earlier during the taking over of these platform as additional equipment or replacement of earlier equipment during the process of expansion of installed capacity of production. Two, the said SSC has stated to have enhanced the capacity of bottle filter from 15 nozzles to 15 nozzles to 50 nozzles. However, a document showed that the 15 nozzles had existed prior to expansion. Three expansion capacities based on certificate issued the district industrial center Jorah 10/5/1993. But subsequent to the issuance of the above certificate, there was no upgradation or modernization of the plant, as a result of which there was expansion of installed capacity prior to 24/12/1997. Following are the legal machinery installed after the above certification. A bottle filter now installed in 1995, bottle washer installed in 1993, bottle converter system installed in 1995, SS converter installed in 1993. E. General diesel generator CW fuel tank installed in 1995, super screw feeder conveyor dated installed in 1998. No expansion of critical machinery. Critical machinery to determine installed capacity in a separated water bottling plant are bottle washer and bottle filter. On the evaluation report and the report of the said SEC was clear that no new machinery had been installed in these two categories and no capacity was built in this area, and the installed capacity remained same. Bottle washer had capacity of 320 bottles per minute and the bottle filter had capacity of 330 bottles per minute, which were the same as in pre-expansion period. Wrong assessment of the installed capacity. The said SEC submitted the following documents to project pre and post expansion capacity of production. A. Pre-expansion capacity 9 lakh crates based on DIC certificate issued on 10/5/1993. Post expansion capacity of 15,1,600 crates based on DIC certificate issued on 7/9/1999. Post expansion capacity of 40,000 crates based on certificate issued by the authorized signatory, the said SEC, based on trade filter capacity. Post expansion capacity of 11,40,000 crates based on certificate issued by the authorized signatory of the said SEC dated 22/9/99. You have the above foregoing paragraph. It was felt that certificate issued by the DIC Jorah dated 10/5/93 cannot be taken as the expansion installed capacity. It does not cover the cutoff date of 24/12/1997. Depend on post expansion capacity of production. As it shows that there is no inclusive post expansion capacity of production, and so the ratio of increasing installed capacity by 35% or more could not be arrived at. Based on the above allegation, the said SSC were proposed by number 22 by the Commissioner Central and Ceylon. Like 5, it is 15 crore 4,35,000 for the period from 1999 to November 2002. Erroneously reported them could not be recovered. So the provision of section 11A of the Central Excise Act and this notice for the identification before the exhibit property. There was earlier proposed notice dated 3/10/2002 for the refund of duty amounting to rupees 12 crore 16 lakhs 76,000 for erroneously refunded to the same agency for the period from July 99 to 8/2, and it has been executed by the Commissioner Excise Ceylon. The Commissioner Central Excise Ceylon had ordered in ordinance that it found the charge brought forward and the so-called notice do not fall due and proceeding initiated with above estimate dated 3/10/2002 were dropped. The Central Excise and Custom review the state order in ordinance dated 99/2003 on the ground mentioned herein and directing the Commissioner of Central Excise to prepare an appeal to the state that together the Commissioner is clearly correct in determining the applicability of notification number 33/99 as amended in the present case. The Commissioner Central Excise should file this to the state right for the 10/12/2003. The state passed order on 21/2005. The Honorable Tribunal held that the report relied upon by the Commissioner clearly shows in detail that there has been substantial expansion of the executive. The language in the notification requires substantial expansion. Specifically, the expansion is not referred to any individual section, stated and secondary text. Relying on the above tribunal's order dated 21/2005, the Commissioner Central Excise order by the original substantial drop the proceeding against the citizen. The committee on examination of the order in ordinance dated 48/2002 found the order not accepted the ground mentioned below. Ground 1. The second so-called notice is related to recovery of the revenue refund for the period from July 99 to November 2002, and there was another so-called notice for recovery of erroneous refund for the period from 99 to 2002, which were dropped by the Commissioner of the Central Excise Law at application order dated 3/2006. The board on the ground mentioned herein refused the said order dated 3/2006, and accordingly, an appeal was filed to the CITES. It appears from the order dated 21/2005. Page 73 of the operating did not discuss the large crowd of the global motive on existence of secondary to pre-expansion period, which saw and installed to the earlier decision. We can clearly strike that what was limited to the that was where the on-court revision report of April 1999 was clear. Thus, really substance the fact that real strength were not placed before the authority at time of claiming of type of notification, which indicates subsection of fact. C. The executing authority did not disclose the charges from declaration made on paper capacity to the effect that the same type 16 notice with the pre-expansion 50 notice, the expansion whereas 15 notice had existed from the beginning. Critical machinery to determine the installed capacity, then indicated water pumping plant, a total watcher and bottle filter, and careful scrutiny which observed that there was no installation of any machinery in those areas. The facility remained the same. The executing authority failed to execute its
explained under of technical not more than 15 crores. Therefore, the line on the third order, the executing order not passed by the past is not application of mine in credit law. The executing authority has not discussed the charge of wrongful expansion, the install capacity, as per the SPN. Whereas the executive claims the benefit of certification on certificate of the DXC issued on 10/5/1993 for the expansion. Post expansion of DXC certificate 79. The certificate dated 10/5/1993 issued by the DXC Dora not be held. The basis for definition of capacity production during the expansion period. As the cutoff date.
Yes, sir. पढ़ने से क्या होगा? What in this, what is the law?
My lord, I apologize to my learned friend if I may be given 5 minutes. I'll just explain what the case was about.
On the case we have already understood
Very well.
that whether there is any substantial expansion in the unit after 1997 or not.
My lord, there's something more. This issue was decided in 2005. They've already given the refund for the previous period. If your lordship kindly comes,
2005, this page 48.
your lordship will kindly come to the impugned order.
No, no,
It explains the,
just a minute.
yes, my lord.
This 2005
Yes.
is
So,
page 48.
no, the 2005 order is in page 48. That's right.
Page
This is not the impugned order. This was never challenged by the department.
So these, they have, for the very same issue, they have
Lordship.
already filed the appeal.
Yes, so what has happened is the notification benefit extends to for a 10-year period. The benefit accrues for 10 years. So in the very first year, that issue went all the way up to the tribunal in 2005. They accepted it. It attained finality over the years. What they did is for the subsequent period, they re-agitated the same issue of eligibility. And now they have come in appeal. If your lordship sees the tribunal order, it's self-explanatory.
Too much.
No,
Scale is too much.
earlier appeal.
That is it.
Into the same. That was.
Sir, in the year 2005, when this exemption was granted, you challenge that,
All orders were challenged.
huh?
All orders were put under check.
Which orders?
Earlier order.
Earlier orders of which year?
Closed by your notice.
Huh?
For monetary.
The page that your lordship had read, 72, which the order in review that my learned friend had referred, your lordship will kindly come to that page only. It is explained in that page.
72.
72. My learned friend had just read out that page.
Yeah.
Yeah, your lordship will see right in the middle, the third paragraph from the top. It starts with the words, the Commissioner of Central Excise. So Commissioner of Central Excise, Dibrugarh, filed an appeal before Sestat. This is the first case, dated 10/12/2003, and Sestat passed an order on 21/2005. The Honorable Tribunal held that the report relied upon by the Commissioner clearly shows in detail that there has been substantial expansion of the industrial unit. The language in the notification requires substantial expansion in the industrial unit, and the expansion is not with reference to any individual section. I'll explain that issue also.
This order of 20th of January 2005 has never been challenged.
Never been challenged. And your lordship will see the answer in the next paragraph. Relying on the tribunal's order, the commissioner by order in original 2006, which is the adjudication order in this period, he dropped the case saying this has already been decided. So when the matter went to the tribunal, he said, the tribunal said, we have already decided this issue. How can we revive it?
What's the question of law? Sir, in the year 2005, in relation to very same industry, the CZ commissioner has rightly, whatever this considered that expansion was there after this 1997, and therefore he entered for this exemption notification, benefits under the notification 99. And again, you are challenging the same, sir. How can it be?
And not only that, my lord, your lordship will kindly come to page 108.
Yeah.
Your lordship will see there is a tabulation which I have specifically provided for your lordship's assistance. Your lordship will see what the first matter was about, which period the first matter covered.
Yeah.
Page 108, your lordship will see there is a tabulation.
Yeah.
Your Lordship will see item number 1. This is the first show cause notice. Your Lordship will see the period is July 99 to May 2002.
Okay.
And Your Lordship will see the second show cause notice, which is the subject matter before Your Lordship. July 1999 to November 2002. Overlapping period, they've already given the eligibility. For the same period, how can they simultaneously say?
ये तो please. What is this?
This is in page 108.
The same period.
Same
not
period,
overlap.
overlapping period. There's 6
Not
months in
overlap,
addition.
Same period.
Same period. There's a 6-month additional period in the second show. That's all I have to say, Madam.
Something else? Work it out.
Deeply applied.
Item 17.
Thank you.
Yes.
Petitioner lordship method is agreed method by order dated 29/11/2023, asking the number 441 of 2021 method. Case 65 method.
Yes.
There might be a case method. Yes, in actual.
Mother died on when?
Well, my father died on 13/1/2015.
13/1/2015.
Method. Thereafter, my petitioner being a graduate method had applied for appointment on functional ground on 5/2/2015.
The petitioner DLC has recommended various case reports for second aspect, the section of the SL not admissibility that admitted.
Pilot here kindly come to page 46. Pilot is a part of DLC pilot recommendation.
Yes.
Now method. The DLC has committed method taking the post of junior assistant method. Therefore, my lord, a state level committee was held, my lord, case 47, my lord. Kindly you lost to sign, my lord. Here, the BFS candidate, my lord, were recommended, my lord. Case 47. but fictional case is not considered, my lord.
47.
47. my lord.
Yeah.
There kindly see, my lord, there are some candidates, my lord. There in the qualification column, my lord, you will also find, my lord, be a pass.
Sir, on 1/4/2024, we directed you, the appellant faced some time to apprise the court in the year 2015 that requisite qualification for appointment on the post of section assistant was not higher secondary science. Show us.
My lord, in that regard, my lord, I had in my additional affidavit, my lord, I have annexed some advertisement, my lord.
What affidavits?
Additional affidavit.
Yes.
Here, my lord, I have annexed some advertisement, my lord. Yes,
So whatever the advertisement shows the rule,
my lord,
section assistant, the minimum qualification is not, this higher secondary science is not required. That's all. Shows the rule.
my lord, that, my lord,
I think so. This was this point is being argued for third and fourth time.
my lord. In fact, my lord, we did not apply for section assistant, my lord. Number of, my lord.
Section assistant, what is the requisite qualification for appointment on the post of section assistant?
My lord,
What was
Now-
the requisite qualification in the year 2015?
my lord, here, my lord. In the, yeah, I had annexed some advertisement, my lord.
Sir, why don't you show us the rule?
My lord, rule, I have, my lord, in fact, submitted the RT application, my lord, taking the rule.
Sir, rules के लिए RTI application,
Well,
who are going to file an RTI application for rules?
My lord, the respondent authority.
You can download it or you'll get in the barracks, you can download it from the Gazette notification. Anywhere you can get the rules.
We have.
Mr. Nath,
Lord, I must apprise your lordship, Lord. I have received the instructions, Lord. As per my instruction, Lord, the appointment to the post of section assistant under PWD prior to 2018 was done at the divisional level by the executive engineer concerned, and the qualification for the post of section assistant at that point of time is class 8 pass. Subsequently, it was in the amended rule in 2018, it was enhanced to say higher secondary science in 2018. Plus, higher secondary science was insisted because the section assistant has a promotional avenue to the post of junior assistant, junior
since
engineer.
2018,
Lordship.
this requisite qualification is higher secondary science for the
Science.
post of section assistant.
Yes, sir. Because they have the promotional avenue to get promoted to the post of junior engineer from section assistant.
And he is graduate.
He is BA.
He is a graduate.
He is a BA.
The 8 pass.
Earlier 8 pass.
Yes, my
Hardly.
lord.
It was a-
You are seeking appointment this time now.
My lord, before 2018, my lord, that is, as my friend has accepted people lost, my lord, that's the 8 pass, my lord. Before 2018. Now I have applied in the 2015. my lord. And my lord, the application. My lord, in fact, my lord, the civil selection committee, my lord, right? Their selection, my lord, can be computed in the external activity. The time going on. Page 80. This is the statement of the page 88, my lord. Here, my lord, real logic will find, my lord, at serial number 22, my lord, one Devopolitan. My lord, he is BA pass, my lord. He was also, my lord, rejected, my lord. And this was rejected, my lord. And in that same very list, my lord, I was at page 92, my lord, at serial number 47. Same footing, my lord, I was also rejected. Now, my lord, this Devopolitan, my lord, had preferred it. People lost him, my lord, subsequently, he had preferred the appeal, my lord, people lost him. And that appeal was the alert. Case 196, my lord, your lordship will find the operative portion, my lord, case 105, my lord.
Yes,
Open method. Qualification concern method.
yeah,
Open method is educational qualification method. Ticket method. The effect code in the case of method, it is your board method. It has held that from the date of application method, that application qualification will be counted. Not from the date of
the
consideration.
Supreme Court has also said that after a substantial time, the hardship goes, and therefore, in every case, it's not a matter of right to be claimed for a compassionate appointment. That judgment is also there.
It might have.
So
Now method can be
what are you doing for last 10 years?
method.
Your father died in the year 2015. How you are surviving?
Method daily wager method. Surviving method in
Daily wager. Daily wager, what job he is doing on daily wager?
speak nothing.
He engaged you, he might have paid you the fees. So seems that if he is able to engage you, then he is having good means of
Sample submission because worship method is there. Method. They think they method. If a chance for a particular situation.
reconsideration. Okay, let us see.
Method. Commensurate with education qualification. Any grade method. Grade 3 or grade 4 method.
Okay. Order is up.